I never thought I'd find myself in a property war with a bunch of power-hungry HOA board members. But life has a way of surprising you. The morning, I discovered construction equipment on the edge of my waterfront property was the beginning of what would become the most exhausting and ultimately satisfying battle of my adult life. My name is Samuel Farley, and for 15 years I've owned 5 acres of beautiful lakefront property on Lake Murray in South Carolina. The house itself sits up on a small hill overlooking the water, while a gentle slope leads down to about 200 feet of private shoreline. It's peaceful, it's secluded, and until the Lakeside Pines Homeowners Association decided to make my life miserable, it was perfect. I remember that morning clearly. It was a warm Tuesday in April when I stepped out onto my deck with my morning coffee, something I've done almost every day since I bought the place. The sound of an engine that didn't belong broke through the usual chorus of birds and gentle lapping of water against the shore. Setting down my mug, I walked to the railing and peered down toward the water. A yellow bulldozer was parked near my property line, and 3 people in hard hats were examining what looked like blueprints spread across the hood of a white SUV with Lakeside Pines HOA emblazoned on the door. I nearly spilled my coffee as I hurried down the wooden steps that led from my deck to the yard. By the time I reached them, they had begun marking the ground with small orange flags. "Excuse me," I called out, trying to keep my tone neutral despite the alarm bells ringing in my head. "What's going on here?" A woman with a blonde bob and oversized sunglasses turned to face me. She wore khaki pants, a polo shirt with the Lakeside Pines logo, and an expression that suggested I was interrupting something important. "Mr. Farley, I presume." Her voice had that artificial sweetness that immediately put me on edge. "I'm Karen Matthews, president of the Lakeside Pines Homeowners Association. We're just marking the area for the new community boat launch." "Boat launch," I echoed, looking from her to the bulldozer and back. "On my property." Karen's smile tightened. "Oh, there seems to be some confusion. This is HOA-designated access land. It's right here in our community plans." She tapped a spot on the blueprint. "I'm sorry, but that's incorrect. My property line extends all the way to that oak tree." I pointed to a massive tree about 30 feet away. "I have the surveys to prove it." Karen's smile didn't falter, but her eyes narrowed slightly behind her designer sunglasses. "Mr. Farley, the HOA board voted unanimously last month to install a community boat launch. The paperwork has all been filed with the county. Construction begins tomorrow." My stomach dropped. "Nobody informed me about this." "The notice was in the community newsletter." She shrugged as if that explained everything. "And we sent an email to all residents." "I'm not a member of your HOA," I said firmly. "My property predates your development by decades. I was grandfathered out when Lakeside Pines was built." The 2 men in hard hats exchanged glances. One of them, a stocky guy with a clipboard, whispered something to Karen. "Be that as it may," she continued smoothly, "this access point is essential for our Marina project. The blueprints clearly show this as community property." I took a deep breath. "You need to stop what you're doing right now. This is private property and you're trespassing." Karen sighed dramatically, as though dealing with a difficult child. "Mr. Farley, perhaps we should have this conversation after you've had time to review the community guidelines. We have all the proper permits." "Permits based on incorrect property lines," I countered. "I'm asking you politely to leave." Now, the tension in the air was palpable. Karen's artificial smile finally dropped. "We'll be back tomorrow to begin construction," she said flatly. "I suggest you familiarize yourself with the plans before then. The boat launch will benefit everyone in the community, including you." With that, She signaled to the two men, and they gathered their things. As they walked back to their vehicles, I heard Karen mutter something about difficult neighbors and community vision. I stood there watching as they drove away, a sense of dread settling over me. I knew enough about HOAs to understand that they often operated like miniature dictatorships, and Lakeside Pines had a particularly aggressive reputation. The development had sprung up around my property about 10 years ago, and I deliberately maintained my independence from their rules and regulations. Back inside my house, I immediately called my friend Patrick, who happened to be a real estate attorney. "They can't just build on your property," Patrick assured me after I explained the situation. "But HOAs can be persistent. Do you have your property survey handy?" I dug through my filing cabinet and found the survey from when I purchased the property. According to the document, my land indeed extended all the way to the oak tree, including the entire shoreline area where they were planning to build. "Email me a copy," Patrick said. "I'll draft a cease and desist letter today. And Sam, document everything. Take photos of your property lines, the survey markers, everything." I spent the rest of the day doing exactly that, systematically photographing every boundary marker and comparing it to my survey maps. I also printed out copies of my deed and property tax statements, which clearly showed my ownership of the disputed land. That evening, I received an email from Lakeside Pines HOA. It contained a formal notice about the boat launch construction and a crude map showing what they claimed was HOA property, a 20-foot wide strip of land cutting right through my shoreline. I forwarded it to Patrick immediately. His response came within minutes. "They're bluffing. The property records are clear." The next morning, I was up before dawn. I set up a lawn chair at the edge of my property and waited with a thermos of coffee and my property documents beside me. Around 7 o'clock, 2 pickup trucks and the same bulldozer from yesterday appeared. Karen Matthews stepped out of one of the trucks, looking annoyed to see me waiting. Today, she was accompanied by a different man, taller, with the confident bearing of someone used to getting his way. "Mr. Farley," Karen called out as they approached. "This is Richard Donovan, our HOA vice president and project manager for the Marina development." Richard extended his hand, which I didn't take. "Mr. Farley, I understand you have some concerns about our project." "I more than have concerns," I replied, holding up my property survey. "You're planning to build on my land. That's not a concern, it's trespassing and attempted theft of property." Richard's friendly expression hardened slightly. "We've filed all the appropriate paperwork with the county. Our surveys show this is HOA common area." "Then your surveys are wrong," I stated, handing him copies of my documentation. "These are the original surveys from when I purchased this property 15 years ago, well before Lakeside Pines existed. My property line is clearly marked." Karen and Richard exchanged glances. "There must be some mistake," Karen said. "Our development plans always included lake access at this point." "That may be what you planned, but this is what I own," I replied firmly. "And I have a cease and desist letter from my attorney that says you need to stop this project immediately." I handed Richard the letter Patrick had emailed me last night. His face darkened as he skimmed it. "We'll have our lawyers review this," he said, folding the letter and tucking it into his jacket pocket. "But the community has been promised this boat launch for months. We've already collected special assessments to fund it." "That's not my problem," I said. "You can't build on land you don't own." Karen stepped forward, her voice dropping to what I assumed was her attempt at being reasonable. "Mr. Farley, we're willing to compensate you, of course. The HOA can offer you $5,000 for an easement through this small portion of your property." I nearly laughed. Lake Murray waterfront property was worth far more than that, even a small strip of it. Not interested, I replied. Now please leave my property. Karen's friendly facade disappeared entirely. This is exactly the kind of selfish attitude that makes community planning so difficult. You're one person standing in the way of amenities for over 200 families. I'm one person protecting what's legally mine, I corrected her. And if your bulldozer crosses my property line, I'll call the sheriff. Richard put his hand on Karen's arm as she opened her mouth to respond. We'll be in touch, Mr. Farley. I'm sure we can work something out that benefits everyone. They retreated to their vehicles, and I watched as the small convoy backed up and drove away. I knew this wasn't over, not by a long shot. I was right. Over the next week, I received daily phone calls and emails from various HOA board members, each with increasingly urgent requests to reconsider my position on the boat launch. The offers increased too, from $5,000 to $8,000, then to $12,000. I declined them all. Patrick advised me to install security cameras covering my shoreline, which I did immediately. It was a good precaution because exactly 9 days after their first visit, I woke up to the sound of machinery. It was just after sunrise when I rushed down to the shore in my bathrobe to find a crew already at work. The bulldozer had pushed past my property line and was clearing trees along the shoreline. Karen Matthews stood nearby, clipboard in hand, directing the operation. "What the hell do you think you're doing?" I shouted over the noise of the engine. Karen looked up, completely unsurprised to see me. "Mr. Farley, we've tried to be reasonable. The board voted last night to proceed with construction while our attorneys sort out the property dispute." "This is illegal," I said, pulling out my phone. "I'm calling the sheriff right now." "Go ahead," she replied with infuriating confidence. "Our permits are in order. This will be resolved in court if necessary, but the community needs this access point now, before boating season is fully underway." I called the sheriff's office, and while I waited for them to arrive, I took videos and photos of the ongoing destruction. They had already cleared a path about 10 feet wide through my trees down to the water. When Deputy Collins arrived 30 minutes later, Karen immediately approached him with a folder full of documents. "We have all the necessary permits," she explained smoothly. "This is a civil matter involving a property line dispute. We've filed the appropriate paperwork with the county." The deputy looked from Karen to me, clearly reluctant to get involved in what appeared to be a complicated property issue. "She's trespassing," I insisted. "I have survey documentation proving this is my land." Deputy Collins sighed. "Sir, if you both have documentation claiming ownership, this is indeed a civil matter. I can't order them to stop construction based on disputed property lines. So they can just build whatever they want on my land and there's nothing you can do." I was incredulous. "You need to get an emergency injunction from the court," he advised. "I can document that there's a dispute, but that's about all for now." I called Patrick immediately, and he promised to file for an emergency injunction that day. But by the time he got it before a judge, the damage was already substantial. They had cleared a 20-foot wide path through my trees and begun laying gravel for what was clearly going to be a boat ramp. The injunction came through late that afternoon, temporarily halting construction until a hearing could be scheduled. But the HOA had accomplished exactly what they wanted. They had established their presence on my land and created a situation that would take time and money to undo. The court date was set for 3 weeks later. In the meantime, the half-finished boat ramp sat like an ugly scar on my property. Worse, despite the injunction, I occasionally caught residents from Lakeside Pines wandering down the newly cleared path to access the lake. When confronted, they invariably claimed they thought it was community property. I installed a chain across the entrance to the path with a "No Trespassing" sign, but it was removed within days. I replaced it. It disappeared again. This cycle repeated several times. The property hearing finally arrived on a sweltering June morning. I arrived at the courthouse with Patrick and all my documentation, only to find Karen, Richard, and 3 other HOA board members already there with their attorney, a polished-looking woman in an expensive suit. The hearing itself was frustratingly brief. The judge, an older man named Judge Harris, reviewed both sets of documents, compared the surveys, and looked at the property records. "It appears to me," he said finally, "that Mr. Farley's survey predates the development and clearly shows his ownership of the disputed area." He peered at the HOA's attorney over his reading glasses. "Miss Peterson, can you explain why your clients proceeded with construction before resolving this obvious discrepancy?" The attorney cleared her throat. "Your Honor, my clients acted in good faith based on the development plans approved by the county. There was an understanding that this access point was essential to the community." "An understanding doesn't override property records," Judge Harris replied dryly. "I'm granting Mr. Farley's injunction. All construction must cease immediately, and the Lakeside Pines HOA is responsible for restoring Mr. Farley's property to its original condition within 30 days. I felt a surge of relief, followed immediately by concern as I saw the expressions on the faces of the HOA board members. Karen Matthews in particular looked like she had just bitten into something sour. Outside the courthouse, Karen approached me. "This isn't over, Mr. Farley. The community needs lake access." "Then buy some lake access somewhere else," I replied. "My property isn't for sale." Patrick put a hand on my shoulder. "Let's go, Sam. You've won this round." But as we walked away, I couldn't shake the feeling that the HOA wasn't going to give up so easily. I was right to be concerned. The HOA complied with the court order technically. They removed the construction equipment and some of the gravel they had laid down. But they did the absolute minimum required, leaving behind a cleared path that was still easily accessible from the road. And despite the court ruling, I continued to find people using the path to access the lake through my property. When confronted, they would apologize and claim they didn't realize it was private property, despite the multiple signs I had posted. 2 months after the court hearing, I returned home from a business trip to discover something that made my blood boil. Not only had the path been completely cleared again, but a proper gravel boat ramp had been installed overnight, extending into the water. A small wooden sign read, "Lakeside Pines Community Boat Access." I immediately called the sheriff's office and Patrick. This time, the responding deputy was more sympathetic, especially when I showed him the court order. "This is a clear violation," he agreed, taking photographs of the newly constructed ramp. "I'll file a report for contempt of court." Patrick was furious when he arrived. "They're betting that fighting them will cost you more than it's worth," he said, shaking his head. "Classic HOA tactics." That evening, I received an email from Karen Matthews. It was brief and to the point. "The board has reconsidered its offer for an easement. We're prepared to pay $25,000 for legal access to the boat ramp, which, as you can see, is already benefiting the community. Please reconsider your position." I deleted the email without responding. Instead, I spent the weekend researching my options. By Monday morning, I had a plan. I hired a local contractor who specialized in fencing and security gates. By Wednesday, I had installed a heavy-duty electronic gate across the entrance to the path, complete with a security camera, and a sign that read "Private Property Authorized Access Only." The reaction was swift and predictable. By Wednesday afternoon, Karen Matthews and 2 other board members were standing outside the gate demanding that I open it. "This is community property," Karen insisted, her face flushed with anger. "No, it's not," I replied calmly from the other side of the gate. "A judge has already ruled on this. The gate is on my property and it stays closed. You can't block access to the boat ramp," one of the other board members, a man named Tom, argued. "People have already scheduled boating activities for this weekend." "The boat ramp shouldn't exist," I reminded them. "You built it illegally against a court order." Karen's expression was venomous. "We'll see what the county has to say about this. You can't just gate off lake access." "It's not lake access," I corrected her. "It's my private property. And yes, I absolutely can gate it off." They left in a huff, and I braced myself for the next round of the battle. It came in the form of a letter from the county zoning department claiming that my gate was in violation of lakefront access regulations. Patrick quickly drafted a response, including copies of my property deed, the court ruling, and photographs of the illegally constructed boat ramp. The county backed down, acknowledging that the gate was indeed on private property and therefore permissible. But the HOA wasn't finished. They began a campaign to paint me as the villain of the community, the selfish homeowner, who was denying families their rightful access to the lake. Flyers appeared in the neighborhood mailboxes. Posts went up on the community Facebook page. Some of my neighbors who weren't part of Lakeside Pines even received letters asking them to speak to Mr. Farley about his community responsibilities. Through it all, I kept the gate locked and maintained my security cameras. And that's how I captured the footage that would finally turn the tide in my favor. It was a Friday evening in July when my security alerts pinged repeatedly on my phone. I pulled up the camera feed to see Karen Matthews and Richard Donovan at my gate with bolt cutters. I watched in disbelief as Richard cut through the chain on my gate while Karen kept lookout. They swung the gate open, and within minutes, a line of cars began driving through, residents heading down to the boat ramp with their watercraft in tow. I called the sheriff immediately and sent the video to Patrick. By the time Deputy Collins arrived, there were at least a dozen cars parked along the path, and numerous people launching kayaks, paddle boards, and small boats from the illegal ramp. This time, there was no ambiguity about the situation. The deputy took one look at the cut chain and the video evidence and immediately began taking statements. When Karen and Richard returned to the gate area, he approached them directly. "Miss Matthews, Mr. Donovan, I need to speak with you about the destroyed property and trespassing," he said, his tone official. Karen looked momentarily flustered before regaining her composure. "This is a community access point," she insisted. "We have every right to be here." "Madam, there's a court order specifically stating otherwise," Deputy Collins replied. "And I have video evidence of you and Mr. Donovan cutting the lock on this gate, which constitutes criminal damage to property." The color drained from Richard's face, but Karen doubled down. "This is ridiculous. The HOA has jurisdiction here." "Not according to the county records and court ruling," the deputy replied. "I'm going to have to ask everyone to leave the property immediately. And Miss Matthews, Mr. Donovan, you'll both need to come to the station to answer some questions." As the deputy escorted Karen and Richard to his vehicle, I watched with a mixture of satisfaction and weariness. The other residents, now aware that they were trespassing, quickly packed up their things and left, many of them giving me dirty looks as they passed. Patrick arrived just as the deputy was leaving with Karen and Richard. "This changes everything," he said, reviewing the footage on my phone. criminal charges for destruction of property and trespassing. Plus, they're in contempt of court. The next few days were a whirlwind of legal activity. Karen and Richard were both charged with criminal trespassing and destruction of property. More significantly, the court issued a new ruling, finding the Lakeside Pines HOA in contempt and imposing a substantial fine, $500 per day, until they removed the boat ramp and restored my property to its natural state. The story even made the local news, complete with the security footage of Karen and Richard cutting my gate. The public response was overwhelmingly in my favor, with many people sharing their own horror stories about overzealous HOAs. The most surprising development came a week later, when I received a letter from the Lakeside Pines HOA, but not from Karen or Richard. It was signed by Patricia Kelly, the new interim president. "Dear Mr. Farley," it read, "on behalf of the Lakeside Pines Homeowners Association, I would like to extend our sincere apologies for the actions of our former board members. Following an emergency meeting, Karen Matthews and Richard Donovan have been removed from their positions on the board. We are committed to restoring your property as ordered by the court and rebuilding trust with our neighbors. We would appreciate the opportunity to meet with you to discuss how we can make this right." I showed the letter to Patrick, who raised his eyebrows. "That's unexpected." "Want me to be there for the meeting?" "Absolutely," I replied. 2 days later, Patricia Kelly and 2 other new board members met with me and Patrick on my deck. Patricia was nothing like Karen. She was soft-spoken but direct, and she came prepared with a comprehensive plan for restoring my property. "We've hired an environmental restoration company," she explained, showing me their proposal. "They specialize in returning disturbed lakefront property to its natural state. The work will begin next week and should be completed within a month." "What about the people who are angry about losing their boat access?" I asked. Patricia sighed. "We've had to be honest with the community. The previous board acted illegally and mismanaged funds. We're exploring legitimate options for lake access, including purchasing a proper easement from a willing seller. Or building your own marina on property you actually own," Patrick suggested. "Yes," Patricia agreed. "That's actually our preferred solution now. We've identified a parcel on the other side of the development that might be suitable." Over the next month, I watched as workers carefully removed the illegal boat ramp and replanted native trees and shrubs along the shoreline. The path was narrowed to a small walking trail that I agreed could remain, provided it was clearly marked as private property with limited access for wildlife viewing only. The criminal cases against Karen and Richard proceeded slowly through the legal system, eventually resulting in probation, community service, and restitution payments for both of them. I occasionally saw them in town, but they always made a point of avoiding me. As for the Lakeside Pines community, the new board made good on their promise to find a legitimate solution. They purchased a small parcel of lakefront property about half a mile down the shore and began developing a proper marina facility with the necessary permits and approvals. The irony wasn't lost on me when, about 6 months after our property dispute began, I received an invitation to the grand opening of the Lakeside Pines Community Marina. I decided to attend, partly out of curiosity and partly to show that there were no hard feelings with the new board. The new facility was impressive: a proper concrete boat ramp, floating docks, and even a small picnic area. Patricia Kelly spotted me in the crowd and came over to chat. "We should have done this from the beginning," she admitted. "The previous board was so focused on cutting corners that they ended up costing the community more in the long run." "It looks great," I said sincerely, and it's actually larger than what they tried to build on my property." Patricia nodded. "That's the other irony. This location is much better for a marina. The water's deeper, and we don't have to worry about disturbing private property." She paused, then added, "Some of the residents have asked if you'd consider allowing a small walking path connection between the communities." "Completely on your terms, of course." I considered it. "Let me think about it. Maybe a limited access nature trail could work." In the end, I did agree to a modest nature trail with clear signage, regular hours, and a proper gate that respected both my privacy and property rights. The new HOA board even contributed to a conservation easement that would protect the natural shoreline in perpetuity. It was a solution that benefited everyone and respected proper boundaries, both legal and physical. As for Karen Matthews, I heard she moved to another lakefront community about a year later. Rumor had it she was running for their HOA board, though her legal troubles from our dispute had apparently made some residents wary. The boat ramp battle taught me several important lessons. First, document everything and know your property boundaries. Second, stand your ground when you're in the right, even when it's difficult. And third, sometimes the best resolution comes not from winning at all costs, but from finding common ground after establishing clear boundaries. My relationship with the Lakeside Pines community improved dramatically under the new leadership. We weren't exactly friends, but we were respectful neighbors. The nature trail became a popular spot for bird watchers and people seeking a quiet moment by the water, and I found I didn't mind sharing that small piece of my property now, that it was being done legally and with respect. The illegal boat ramp incident became something of a local legend, a cautionary tale about HOA overreach that real estate agents even mentioned when showing properties in the area. "Yes, this community has lake access," they would say, "and unlike Lakeside Pines, we actually own it." About 2 years after the incident, I was approached by a local journalist writing a feature about homeowners associations in the region. She wanted to include my story as an example of both HOA overreach and eventual resolution. "What would you say was the turning point?" she asked as we walked along my restored shoreline. "When did things finally start to improve?" I thought about it for a moment. "When I put up that gate," I replied finally. "It forced everyone to acknowledge reality that this was private property and that boundaries matter. Sometimes you have to physically demonstrate your boundaries before people will respect them." She nodded thoughtfully, taking notes. "And what would you tell someone else facing a similar situation with their HOA?" "Know your rights, document everything, and don't back down when you're clearly in the right," I said. "But also be willing to find reasonable compromises once the fundamental issues are resolved." The article was published a few weeks later, and to my surprise, it generated considerable discussion in HOA circles across the state. Several community boards reached out to Patricia Kelly for advice on how to reform their own governance practices. The following summer, I received an unexpected letter. It was from a homeowner in a community about 30 miles away, thanking me for standing up to the Lakeside Pines HOA. "Your case gave me the courage to challenge our own board's illegal actions," he wrote. "Sometimes one person has to take a stand before things can change." That letter meant more to me than the legal victory ever did. The idea that my experience had helped someone else stand up for their rights was deeply satisfying. Life on Lake Murray returned to normal, peaceful mornings on my deck with coffee, quiet evenings watching the sunset over the water. The trees and native plants along my shoreline grew back, eventually obscuring any evidence that a boat ramp had ever been there. Occasionally, I would notice someone walking respectfully along the nature trail, pausing to watch herons fishing in the shallows or turtles sunning themselves on logs. These moments reinforced my belief that sharing access wasn't the problem, it was the entitlement and disregard for property rights that had caused the conflict. The Lakeside Pines community Marina thrived under the new board's management. They even won a county award for environmental stewardship based on their sustainable design and commitment to protecting the lake ecosystem. Patricia often joked that they had Karen Matthews to thank for that. Her disastrous boat ramp attempt had ultimately led to something much better. 3 years after the incident, I was considering some renovations to my house when I received another unexpected communication, this time from a real estate developer interested in purchasing a small portion of my property adjacent to the Lakeside Pines development. "We're planning an expansion," the letter explained, "and your parcel would provide ideal access to the new section." I couldn't help but laugh at the irony. Here was yet another attempt to use my property for someone else's access needs. But unlike Karen Matthews and her illegal boat ramp, at least this developer was approaching me openly and legally. I declined the offer, but it reminded me how valuable lake property really was and why the HOA had been so determined to claim a piece of mine. Waterfront access was a premium amenity, one that significantly increased property values and community desirability. The experience also changed how I viewed my own responsibilities as a property owner. While I had every right to protect my boundaries, I also came to appreciate that being part of a larger community meant finding reasonable ways to coexist. The nature trail was a small concession that created significant goodwill, and it cost me very little in terms of privacy or property rights. 5 years after the boat ramp incident, I spotted a familiar face at the local hardware store. Richard Donovan, Karen's accomplice in cutting my gate, was examining paint samples in the next aisle. When he noticed me, he looked momentarily uncomfortable before approaching hesitantly. "Mr. Farley," he said, extending his hand, "I don't know if you remember me." "I remember," I replied, shaking his hand despite my reservations. Richard looked down at his paint samples. "I wanted to apologize for what happened back then. I got caught up in Karen's vision for the community and lost sight of what was right. It was a mistake I've regretted ever since." His apology seemed genuine, and I appreciated the effort it must have taken to approach me. "Water under the bridge," I told him. "Or I guess, water under the proper community marina." Richard smiled weakly. "They did a nice job with that, much better than what we had planned." He paused, then added, "I'm not on the board anymore, obviously, but I still live in the community. Your nature trail is quite popular, you know." It was a generous thing to allow. We chatted for a few more minutes about neutral topics: the unusually rainy spring, the rising price of lakefront property, his new job at a local bank. As we parted ways, I felt a sense of closure that the court rulings hadn't provided. The boat ramp battle had consumed nearly a year of my life and caused considerable stress, but it had also reinforced important principles about property rights and community governance. The Lakeside Pines HOA had been transformed from an adversary into a reasonable neighbor, and my own property was more secure than ever. The following spring, I was surprised to receive an invitation to join a newly formed Lake Murray Conservation Committee, a group dedicated to protecting the lake's ecosystem and promoting responsible development along its shores. Patricia Kelly had nominated me, citing my commitment to preserving natural shoreline and wildlife habitat. I accepted the position, finding unexpected satisfaction in helping shape policies that would protect the lake for future generations. At one of our meetings, a county commissioner remarked that the boat ramp dispute had actually sparked important conversations about lakefront development throughout the region. Sometimes it takes a conflict to expose the gaps in our systems, he observed. Your case highlighted the need for better oversight of HOA activities and clearer protection of property rights. The committee's work led to new county guidelines for shoreline development, including stricter requirements for HOAs seeking to build community access points. Any new boat ramps or marinas now required extensive environmental impact studies and clear documentation of property ownership or easements. As I reflect on the entire experience now, 7 years removed from those tense confrontations with Karen Matthews and her bulldozer, I'm struck by how a seemingly straightforward property dispute evolved into something much more significant both for me personally and for the broader community. The illegal boat ramp that once threatened my property rights became the catalyst for positive changes. A reformed HOA with transparent governance, improved county regulations protecting lakefront property, a properly built community marina, and a conservation-focused nature trail that balanced private ownership with limited public access. I still enjoy my morning coffee on the deck, watching the sunrise over Lake Murray. The view is as beautiful as ever, perhaps even more so now that the shoreline has fully recovered from the HOA's intrusion. The native plants and trees have grown back stronger, providing habitat for countless birds, fish, and other wildlife. Occasionally, I notice people enjoying the nature trail, respectfully staying on the marked path and appreciating the natural beauty of the lakefront. It's a reminder that sharing access wasn't the problem, it was the entitlement and disregard for boundaries that created the conflict. In the end, the gate I installed to keep trespassers out became a symbol of something more important: the necessity of clear boundaries in fostering good relationships. By firmly establishing what was mine, I paradoxically made it possible to share a small portion of it on my own terms. The Lakeside Pines HOA learned a valuable lesson about respecting property rights and following proper legal procedures. I learned that standing your ground doesn't mean you can't eventually find common ground. And Karen Matthews, I heard she finally got elected to an HOA board in a retirement community near Charleston. I can only hope she learned something from our encounter, though I have my doubts. Some people are so convinced of their authority that even legal consequences don't change their perspective. As for me, I've become something of an informal consultant for homeowners facing similar battles with overzealous HOAs. My advice is always the same: know your rights, document everything, and don't be intimidated. Property rights matter, and sometimes one person standing firm can make all the difference. The boat launch that the HOA built through my property ultimately led to something better for everyone involved. My property rights were affirmed, the community got a proper marina facility, and the ecosystem of Lake Murray gained additional protection through our conservation efforts. It wasn't the path anyone would have chosen, but sometimes the most difficult journeys lead to the most worthwhile destinations. And as I sit on my deck watching the sun set over the peaceful waters of Lake Murray, I can't help but feel that despite all the stress and conflict, things worked out exactly as they should have. The property is mine, the boundaries are clear, and peace has returned to this beautiful stretch of lakefront, a peace made possible because I refused to let an HOA build a boat launch through my property, and had the courage to gate it off when they tried anyway.